Good morning.
Good morning. May it please the Court. My name is Gail Strassfeld. I represent Janira Boria in this request to reverse the denial of her new trial motion. The question before this Court is what kind of remedy will be provided to Ms. Boria for the violation of her Sixth Amendment right to confrontation based on the erroneous admission into evidence at her trial of a drug certificate. Ms. Boria's trial took place after Verde, after this Court's decision in Verde, and her appeal was final before the Supreme Court's decision in Melendez-Diaz. And this case is before the Court on a collateral attack. We've asked the Court to apply to this case the same futility analysis that the Court applied in last year in Vasquez, because we think it's really analogous. The same futility that applied at the trial level also applies at the appellate level. In Vasquez, the Court said that it would have been futile for the trial counsel to object.
I thought your argument was that it was manifestly unreasonable for her not to have raised this on appeal.
Well, that was what the case started with before this Court had decided Vasquez. And there's a substitute reply brief that addresses.
Oh, okay.
I suppose the first question is whether Melendez-Diaz promulgated a new rule.
Well, I can address that as the first question.
I mean, if the answer is yes, then you lose.
Well, I think the answer is no,
Okay.
and I will address that. I had originally looked at the Vasquez opinion, where the Court said that because Verde bisected the line between Crawford and Melendez-Diaz, that required a different analysis in that case, which also had raised the issue of whether Melendez was a new rule. And the Court didn't address that issue because it thought it required a different analysis. I think the same applies here. I could do that analysis.
Well, if it's not, I mean, if it's a new rule, you lose.
Well, I don't think so. Can I first address why I think it's not a new rule?
Okay.
Because if you look at the opinion itself in Melendez, it tells us why it's not a new rule. And that's what the Supreme Court does. It looks at the case in which it decides, makes a decision, and it sees what it says there about whether it's a new rule. And in Melendez, the Court repeatedly says, we're just applying Crawford.
That's what they say. That's what they say.
Correct.
But they've said that in other occasions, and that doesn't necessarily mean it's not a new rule.
Well, I don't know. If they said that in Yates v. Aiken, where they're deciding whether Francis v. Franklin was a new rule or not, the first thing that they did, in fact, to decide that it was dictated by precedent, was to look at what the Court said in Franklin.
In Wharton v. Bakhtin, whatever,
Yes.
I'm pronouncing it correctly, the focus on whether it's a new rule seems to be on not the U.S. Supreme Court jurisprudence, but on the state court jurisprudence. If the state court, if the new rule announced changes a decision of a lower court, of a state court that was made in good faith, that seems to be the focus of the new rule analysis.
Well, I think that I respectfully disagree. I think the Supreme Court looks at its own precedent.
Well, maybe when it was talking about Melendez-Diaz.
Also, when it was talking about Francis v. Franklin, was that a new rule, or was it just dictated by the precedent of Sandstrom versus Montana? It looked to the opinion in Francis. It said where the Court said we're just applying Sandstrom, and it said, okay, that's not a new rule. And in Teague versus Lane, which sets out the process of looking at whether it's a new rule or not, they refer approvingly to the analysis that the Court did in Yates versus Aiken. So I think it's, to be sure, there's a dissent, but there was a dissent.
Oh, a dissent, for sure.
Well, and there was a dissent in Francis v. Franklin. They had 3 judges who were in the dissent there had been in the majority in Sandstrom. Nonetheless, it was not a new rule.
Well, so let's think about this for a moment. This is, you've got Crawford. Crawford had nothing to do with scientific tests or official records or anything of that sort.
Well,
You've got Crawford. All right, Crawford overrules Roberts. Chief Justice concurring in Crawford saying, this really doesn't have any effect on business records or official records, because those, of course, have always been admissible. You've got jurisprudence from all over the country going back, well, over 100 years, distinguishing this segment of evidence, of records, official records, of facts, as not being implicated by the Confrontation Clause. So you now have Melendez-Diaz saying, oh, well, yes, actually, they are. That is a huge change, regardless of what Justice Scalia says at the very end. A mere application. Well, it's a huge, gigantic change, taking a whole block of evidence that for hundreds of years had been considered not to implicate the Confrontation Clause and saying, now the Confrontation Clause is implicated. You don't think that's new?
I don't think that's new. Okay. First of all, I don't think it was just Justice Scalia saying that. I think it was Justice Thomas in his concurrence saying clearly these are affidavits, clearly those are testimonial statements.
If I read Justice Thomas's concurrence, if it hadn't been an affidavit, it probably would have been admissible.
But this
if
is
the police officer simply said, I have the report here, it's an official report, and it says that it was X, it would have been admissible.
Those aren't our facts. The facts are that it was a certificate of drug analysis, that was an affidavit, that not only Justice Thomas, not only Justice Scalia, but the rest of the court that wasn't dissenting believed it was a straightforward application of Crawford. Crawford says, here are some statements that are testimonial statements under the Sixth Amendment. It's not going to list let me step back. It does list affidavits. It does list statements that are made to prove facts at trial, and it does list that things that are that can be expected to be proved at trial, and so that's why the court found that the certificates of drug analysis fit precisely within the core class of testimonial statements. And even the dissent said that's just a wooden application of Crawford. So they weren't arguing whether Crawford applied. And if Crawford applied, you can't have a new rule. This court, the Supreme Court, all appellate courts take general rules and apply them to particular factual scenarios. And not each time. In each time, you don't get a new rule.
I understood that. But I'm just saying this strikes me as different in its implications. A whole area of evidence that for hundreds of years has been admissible, at least in this Commonwealth, and Crawford seems to suggest, certainly the Chief Justice in Crawford, that, of course, Crawford does not affect this category of materials, and now in Melendez-Diaz, 5 judges say, well, actually, it does. And I don't understand why that isn't a new rule.
Because when the court is setting out the Crawford rule, it is intending it to apply to various factual scenarios. And each time it applies to a different factual scenario is not a new rule.
Understood. There's different kinds of testimonial evidence. That's true.
So this was simply saying, I have an affidavit, I have this drug certificate. Let's look at what the purpose of this drug certificate is. Let's look at what it says on the drug certificate. And let's see if it falls within the core class of testimonial statements.
And the notion of this being a wooden rule, I think, relates to the fact that this is called an affidavit as opposed to what it is, which is the result of a very simple scientific test, is sort of a wooden application to this notion of affidavits. Well, not that this is somehow obviously covered by Crawford.
I would disagree that it's just an application of a simple scientific test. Every scientific test has a rate of error in it. No scientific test is infallible. So it's not just a recording of what happened. It's someone making an analysis of the drug. We're talking in this case, Ms. Boria's case, 0.15 of a gram. That's 5/1,000ths of an ounce. I mean, I don't know what that looks like. So, I mean, it's not a trivial matter when someone does that analysis and swears, as in an affidavit, to the truth of it, and it is admitted as evidence. The Commonwealth relied on it in its closing and said to the jury, you have to decide whether it's a Class B substance. What should you look at? You should look at the certificate of analysis because that's what it is.
But you agree, I'm sure, that there can be critical bits of evidence, even under Crawford, for which there's no right of confrontation, but they're still admissible because they're part of the historic exceptions to the right of confrontation, business records being among them.
Dying declarations?
There might be. That's not my case here.
Well, no, but isn't that the problem? I mean, because Crawford says two things. Crawford says there is this right of confrontation, but there are exceptions. What was ambiguous after Crawford was the extent of the exceptions. Melendez-Diaz clarifies that this is not, although this was viewed as an exception historically by courts, the Supreme Court is no longer going to view it as an exception. Isn't that the new part of Crawford?
Your Honor, I'm unfamiliar with the Supreme Court ever deciding that this kind of certificate was not within the Sixth Amendment. I understand that.
I'm not saying the Supreme Court said it. The Supreme
Right,
Court spoke of the historic exceptions for business records and for official records, and this court in Verde said that these were akin to them and therefore essentially put them into that exception.
Right, but they weren't the same as business records. They were akin to them. And so, and they weren't akin enough because they were more like an affidavit and were treated as an affidavit by the Supreme Court. So I think that there may be other situations, but I think in this particular case where you have the drug certificate, which is an affidavit, that it is not a new rule. I think that even if you were to find, and because it's not a new rule, it is applicable to Ms. Boria's case. And you should apply the same analysis of the futility to her case so that her failure to raise it on direct appeal is not waived and that she gets the standard of harmless beyond a reasonable doubt.
If we can go to that.
Yes.
Let's assume that she had argued this. Case would be heard after Verde. Appeals court would say Verde's good law, denied. FAR, denied.
Right. Correct.
And that would all be before Melendez-Diaz.
Correct.
So what difference does it make if we apply futility to the failure to include it in the appeal, because the appeal would have been concluded in any event before Melendez-Diaz?
I'm assuming that because she's bringing it on a collateral attack and it's a new trial motion, that if we did not have that she would have waived her right to have it reviewed under harmless error standard. If Your Honor is telling me she would still get that right, even.
Okay, so I mean, I'm trying to figure out whether you're saying if we view it, if we agree that it should be heard on collateral review, then we should treat it the same way we would on direct review.
That's correct.
Okay, but you're not then saying that if this were to be viewed to be a new rule and therefore we would not consider on a collateral review, that the fact that the appellate attorney failed to raise it still allows you to win.
Well, I actually do. In the alternative, I raise an ineffective assistance of counsel.
Right, and I'm trying to figure out how that would work.
Okay,
because,
so how does that
as far
work?
as I can see it, even if she had brought it, she still would have lost. The FAR would still have been denied because Verde was still good law.
Okay.
And I don't see how it would have
on that
mattered.
claim, how do I get there? Well, I think it was manifestly unreasonable, even if it was futile under this court's law. This was a federal constitutional claim.
But you would get there, I take it, you would say it was manifestly unreasonable, A, not to raise it, and B, not to ask for a stay.
Well, not necessarily to ask for a stay, but if you lose on direct appeal, if you raise the issue and lose on direct appeal, like others who did this, you could apply, and cert was granted. It was a time when cert was already granted by the Supreme Court. You could apply for cert. You could petition for cert to the Supreme Court. And several other Massachusetts cases did that. Those cases were held until the Supreme Court decided Melendez-Diaz. They were remanded to the appeals court, and they were reversed. That's what I say should have happened. And particularly here, Ms. Boria was facing a 5-year mandatory sentence. It's not a light sentence. It's a long time. It was a excuse me.
No, go ahead.
So you have to consult with your client. Here's a constitutional claim. It's not a sure winner, but here are the risks, here are the benefits. What do you want to do? That didn't happen here. You
I take it wasn't even the defense. This wasn't even the defense. This has nothing to do with how the case was tried.
It's not, no, but neither was the issue that was raised on appeal. The only issue that was raised on appeal was a statutory interpretation of 32 AD, which also the appeals court in its memorandum said it was powerless to change.
In your argument on futility, are you saying that we should look at this case right now as if appellate counsel were arguing on the direct appeal?
That's right. It was the same thing as the trial, at the trial level. Trial counsel...
But that gets around the new versus the old.
Yes, it does. That's why I raised it first.
But it seems that you're also saying that it is ineffective for counsel where the Supreme Court had taken cert in Melendez-Diaz not to apply for cert in
Well, I'm
this
not
case.
saying, it wasn't only because of cert in Melendez-Diaz, because there was an objection. In this case, there actually was an objection based on the Sixth Amendment to the introduction of the evidence. Well, it used the same language the court used in Verde.
But he said it was a business records.
That's what the court said in Verde when it was applying Crawford. It's the same thing. This court in Verde said we're looking at Crawford, but it's akin to a business record. Trial counsel gets up there and he says the same words. So what I'm saying is, so you had Crawford. The appellate counsel had Crawford, and could have raised it. There was no risk to raising it. There was no downside to raising it, and there's no benefit not to raise it.
Counsel, I'm sorry, but your time is up.
Thank you. So we just asked the court to reverse the denial of new trial motion.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, the defendant would apparently have the court stop its analysis of what a new rule is with Yates versus Aiken. The Supreme Court applying Teague versus Lane has gone far beyond that in subsequent case law and made it quite clear that it's a new rule is any rule that it is a new rule. A new decision amounts to a new rule unless it would be objectively unreasonable for any jurist prior to that case to arrive at a different determination. It's not just a matter of what the author of the new decision says. That was the situation that was addressed in Butler versus McKellar. That's 494 U.S. 407. They say that authors often talk about the strength of their own opinions. That can't be decisive. It has to be viewed in terms of whether, ultimately it's terms of whether they can demonstrate that it would be objectively unreasonable under the law existing at the time to arrive at any other decision than the one that was announced in the new decision. That case.
But let me ask you this, though. I mean, just Padilla.
Padilla, Your Honor.
Supreme Court says it's not a new rule. I mean, but they didn't use this unless it was objectively unreasonable, because lots of courts have said this was never, this wasn't required.
Your Honor, I don't know that Padilla actually specifically addressed retroactivity. What I'm suggesting, Your Honor, is they applied it. I know they applied it. I don't know if they applied it in that case, and I do believe that case. I listened to the court's argument that's here earlier this last month, I think it was, and I heard the argument then, and it appeared, I understood that it appeared that that case was presented to the Supreme Court on a collateral review, and they applied the case. But I don't believe they were in any way suggesting they were overruling Odell versus Netherlands, for instance, or Beard versus Banks, for instance, where they say that it is a new rule unless reasonable jurists would be obliged to arrive at that same decision. And this is not a situation like Yates versus Aiken. In Yates versus Aiken, they're addressing a situation where in Sandstrom, the court was reviewing a jury instruction that said a person is presumed to intend the ordinary consequences of their actions, and the court found that whether you viewed that as a conclusive presumption or a rebuttable presumption, it was a violation of due process. Then in Franklin, they come down and they're considering a situation where the instruction is that malice is presumed from the use of a deadly weapon, though it can be rebutted. That's just a narrower version of the same principle that is the person intends the ordinary consequences of their acts. Therefore, quite reasonably under any standard, you'd say that that wasn't a new rule, but just an application of the prior Sandstrom position. Here it's quite different. You had Crawford with a ruling that the confrontation clause applies to testimonial evidence, but it doesn't give any kind of definitive definition of testimonial. It leaves it wide open. The majority opinion says that business records are outside of that. One of the concurrences suggests that public records or official records are also outside of that, and there is a division amongst quite reasonable jurists, including this court, that say that it does not apply to certificates of analysis like was used in here under well-established law in the Commonwealth going back to Slavsky, Your Honor. I don't think the defense can reasonably say that this court was unreasonable in deciding Verde, or that the variety of other jurisdictions that decided similarly throughout the country were
But it's
unreasonable.
It's easy to persuade us that we were not unreasonable. The problem is that you've got a Supreme Court decision which says this was a slam dunk. This is pure Crawford. Why are we struggling with this? And ultimately, the Supreme Court's going to be deciding this question. I mean,
No, Your Honor. I mean, ultimately, this is as per Danforth versus Minnesota, that this kind of retroactivity analysis is predominantly a matter of state law for state.
Can I stop you there?
it could be if we were to go beyond that, but if we basically say, no, we're going to follow the Teague analysis, then if the U.S. Supreme Court says this is not a new rule, then aren't we bound by saying this is not a new rule?
No, I don't believe so, Your Honor, because it says that Danforth says that it's quite clearly a matter of state law analysis, and one traditional and still accepted version of what amounts to a new rule is any rule that overrules established precedent. And there's no question that as a matter of state law, this is a state law analysis primarily, as a matter of state law, Melendez-Diaz quite clearly overruled Verde and case law going back to Slavsky.
Let me understand, though, Mr. Thompson. You're saying, I mean, I know Danforth says states can be more generous in its application of this to allow appeals that Teague versus Lane or collateral attacks that Teague versus Lane wouldn't. But you mean we can be less generous as well? I mean, we can something that the U.S. Supreme Court would say clearly is not a new rule. We can say, well, since we had some precedent in our state that's to the contrary, we're going to call it a new rule for our purposes. Can we do that under Danforth?
Your Honor, frankly, Your Honor, I know that Danforth says it's primarily a matter of state law. I have not seen any retroactivity case that specifically says that the federal analysis is binding on the courts. I don't think I need to take that position here because I'm saying that any reasonable measure of this. Your Honor points out that Scalia, in a decision joined by only 3 other justices, says that this is an absolutely straightforward application of Crawford. I point out again that in Butler versus McKellar, the court addressed that very point and said that just because the author says that it's just a straightforward application, even if it's considered bound by the prior precedent, even if it's considered controlled by the prior precedent, that's not enough to make it a new rule for retroactivity Teague versus Lane analysis purposes. Again,
Enough to make it a new rule or an old rule?
Make it not a new rule, isn't that what you mean?
enough to make it not a new rule. Yes, Your Honor. I mean, I'm sorry if I misspoke. Your Honor, the analysis from Odell versus Netherlands and Beard versus Banks, which are quite after Teague versus Lane, after Butler, after mostly way well after Gates versus Aiken, says that the measure is whether reasonable jurists could have arrived at a different decision, Your Honor. And the fact that numerous jurisdictions all over the country, several justices of the Supreme Court, this court, all arrived at different decisions than Melendez-Diaz is quite strong evidence that reasonable jurists could indeed reach that
But
point.
by that standard, virtually every Supreme Court case would be viewed as a new rule because the Supreme Court resolves conflicts among the courts. So if there's no conflict in the court, why would the Supreme Court take cert on the matter?
And that is the appropriate thing. The retroactivity is an exceptional circumstances. These only apply to cases that have been decided according to law in existence at the time as having come to a conviction after a fundamentally fair trial. That's why it is a particular narrow exception to that you open up old cases for collateral review of this kind.
If I could move to two other points. One is putting aside the old rule versus new rule. Assume you're right. Assume it is a new rule. Ms. Strassfield says even if it's a new rule, we should still find that counsel here, the appellate counsel, was ineffective because knowing that the Supreme Court had taken cert in Melendez-Diaz, the attorney not only should have raised it before this court, but also should have applied for certiorari and tried to obtain the same benefit that may have been obtained by piggybacking onto Melendez-Diaz.
Your Honor, the reply brief in this case, and certainly the CPCS amicus brief, argue quite stringently in terms of for the futility analysis that no reasonable attorney could have been expected to raise this issue. This court in Vasquez has already determined that counsel could not be expected to raise this issue.
But there's a difference between raising it at trial, where the Superior Court judge is going to say, "I've got an SJC decision, it's denied," versus seeking to raise it on appellate review and hoping to reach the Supreme Court of the United States, which has taken the case. It's hard to say it's futile when the Supreme Court has decided to address the issue.
Your Honor, this court in Vasquez at 456 Mass at 357 Note 8 said because the judge was bound by Verde, the outcome would be no different had the trial occurred after the Supreme Court granted certiorari, but before it had issued the Melendez-Diaz decision. That would apply equally to a counsel on the appellate court. The appeals court was still bound by Verde, and this court would presumably follow Verde as well.
This court would.
Yes, but it's only one more step. I mean, the appellate counsel is in a position to say, yes, that's going to happen. It's futile here, but having seen in March of 2008 that the Supreme Court took Melendez-Diaz, if I do that, I can go, just what Justice Gans saying, I can go to the U.S. Supreme Court and I may get relief.
As a matter of principle, Your Honor, the trial attorney is in the exact same position. He could look forward in the same way and say that I should raise this issue in hopes of someday reaching the Supreme Court. That's been the traditional sort of analysis of these things. This court ruled quite differently in Vasquez. And if you're going to take that position, Your Honor, I suggest you need to go back and essentially overrule Vasquez that says that this was just futile, because the possibility of putting in an objection just to preserve some kind of later federal review has always been there. It was always there for trial counsel, for appellate counsel, for everyone, and it doesn't make any difference that it just reached the appeal. Beyond that, counsel had no particular reason to assume that granting cert was going to mean that Verde was overturned. The counsel here says that they looked at it, they took their analysis, they considered the weight of it, and they decided not to raise the issue. They're aware of it, but they decided not to raise it because their view of the weight. That is a quintessential tactical decision by an appellate attorney. The mere fact that there was some possibility of some future change in the law cannot be enough to require counsel to raise every issue. There is a variety of case law that suggests that it is not ineffective to fail to raise every single non-frivolous issue.
Mr. Thompson, if we don't agree with you and get to the question of the error itself, I'm trying to figure out what standard of review we apply, substantial risk or the prejudicial error standard. Why wasn't this error properly preserved by trial counsel?
Because what trial counsel said, all he said was, I make an objection in view of the case law coming down on the business records exception, or concerning business records. There was no suggestion that he was talking about the confrontation clause. There was no mention of Crawford. There was no suggestion there. On its face, all that applies to is a hearsay exception. It suggests that he was arguing that the Commonwealth had not met the foundation for the business records exception. Would say, Your Honor, that confrontation was not an issue that was being raised throughout the trial. I would suggest this court look at Commonwealth versus Grenadier, it's 458 Mass 407, where the court says if an objection is unclear on its face, then you look at the overall trial strategies to see whether this kind of confrontation issue was raised during the trial. It was not, Your Honor. It was not raised in any way whatsoever. There was never any kind of challenge to the nature of the substance of the weight. From the opening statement of the defendant's counsel and throughout the trial, the defense was addressing this stuff and characterizing this stuff as cocaine. It just was not an issue there, and that counsel here, in looking at that thing, would be faced with a at least questionably preserved issue, weak on the facts of the case, and in face of Verde. It was not an unreasonable choice not to raise it on appeal, Your Honor. And beyond that, in terms of the argument that they did raise, they had some hope of getting the appeal, the sentence reduced from 5 years down to 1 year. If so, the defendant would be open for virtually immediate release by the time of the appellate decision. If they took the step to try to preserve...
Mr. Thompson, time is up. Thank you.
If I could just finish my one sentence, Your Honor.
Yes.
Just that if they took to try to preserve the issue down the federal road as far as to applying for cert and all that, they risked jeopardizing any possible benefit from the other argument they're raising on appeal. Thank you, Your Honors.